about today is creation of a trial notebook for an upcoming trial. And there will be 3 separate books which contain more or less the same information but will differ. There'll be one for us, there'll be one for the opposing counsel, and there'll be one for the judge.
Right. The ones for the opposing counsel and the judge are going to be identical. It's going to be just a thin binder. The one for me is going to be just basically a lot of it is going to be my notes. You know, we put blank notepad in there so that I can make notes for the closing argument. The opening statement I'll have prepared beforehand, but I'm going to probably make some changes to it. So all that's not something you have to worry about.
So what I've got is, as far as structure goes, I've got basically 5 tabs here. In the first tab, there's going to be the opening statement, and that'll be it. That'll be for you, but on the judge and the opposing counsel notebook, that'll just be blank.
Right, and the thing with this one is we're on the defense. We're representing the homeowner, and our position is that there's no valid mortgage because the condo conversion was never complete. So I go second. So the plaintiff is gonna go first on the opening statement. So my opening statement, I'm gonna have a statement prepared, but it's going to be flexible based on what she says.
It'll be in response to that as well, indirect.
Exactly.
Okay. All right, and the second tab I've got is case materials. Now this is going to be the judge's rules, and we just talked about that briefly a minute ago by maybe going on to the circuit court website, finding the docket, and seeing if the judge has any specific rules or wants for his courtroom for that particular trial. Is that the case?
That's exactly right. And just to let you know, most judges, this judge didn't do it, but most judges, when they have a trial order, they'll specifically list, you need to send your list of witnesses by X date, and you need to do this and this and this by this date. This judge really didn't have anything, so it's presumed that he, they get these, it's residential foreclosure, and he's probably just thinking it's just like a regular foreclosure where nobody's going to show up or nobody's going to really do
right, uncontested basically, except for the
exactly.
I can't pay, Judge. All right, now here's something else. What you see under this pile of papers here is pretty much the file. So you're asking me to duplicate this in triplicate. So each of these notebooks are going to be voluminous.
No.
Or is there specific documents you need and others you don't need?
Yes.
Right,
any exhibits are going to be marked. Betty will get you the little exhibit stickers. The exhibits in this case are going to be basically, evidence showing that the condo conversion was never completed, as well as evidence of they're going to produce the note, they're going to produce the mortgage.
So we don't need, you're saying don't put that in there? Because the mortgage is 28 pages alone. I'm going to do that 3 times. So I don't
no,
need to do
yeah,
that.
I'd say if we attach the complaint and our answer with affirmative defenses. Now the complaint is going to include all that. It's going to include the note and the mortgage, which is fine.
Right.
And then our answer with the affirmative defenses.
Right.
And then I don't think they've ever answered our affirmative defenses. So I may move for for directed finding at the time of the trial. Because we've raised affirmative defense and they haven't answered it, so that's that's something that I may file a motion for that, but we'll talk about that later.
Okay.
And then the witness list. The witness list.
Let's talk about that right quick. On this particular one, you suggested to me the other day that the attorney for the condo association may be a good witness. None exists, but however, there was a.
I see the file. Actually, I don't want to use names because it's being videoed,
but none exists.
There was an attorney that was involved. In fact, the HOA was served.
I couldn't. Indeed, they were, and they're listed as co-defendants. But under that there is no notation for the attorney. Only the chairman of or the board of directors of the condo.
Well, now, he never filed an appearance, but he's on the service list. We'll talk about that later. But yeah, I'm going to list him as a witness. Doesn't necessarily mean we have to call him. But
so he will be listed. That was what I was going to ask you, because in here also is depositions. So we never deposed him, and none exists, and it's too late to do that now.
Yeah, I think if we just list them as on the witness list, we're protected. We're probably not going to call them.
Okay. But will there be any others?
No, not that I can think of.
Okay. All right. So that closes out case materials. Tab 2.
Right.
Now tab 3 is going to be exhibits. Now you talked in case materials are going to be up here, but the exhibits are going to be different.
The exhibits I can think of on this one would be if you go on any evidence showing that the condo conversion failed, that would be correspondence. We can maybe get some of that from the client. Client wants to come in and meet before trial, so we can get with him on that. Just any evidence showing that there's no valid supporting our position that there's no valid mortgage because the HOA conversion was never completed and it's still one big apartment building.
Okay, and then we've got the defense's evidence, which could be non-privileged information. What specifically may that be?
Well, just what we. I mean, the exhibits and the evidence. Yeah, the exhibits and the evidence are the same, but I'll work within that. And then the other thing is, my job within the next couple days is to get some compelling case law that supports our position. So I'm going to need to research that.
I was going to ask you about that too.
Now, the case law, we put that at the very end of the trial notebook, and it's not an exhibit. It's just case that we just provide to opposing counsel as a courtesy, and then we give it to the judge at the end of the trial to help him make his decision.
Okay, because you on my outline here, you had said that that's not an exhibit, but now that's going to actually just go toward the end.
Yeah, it'll be at the end, and in fact, we may do a memorandum of law on it.
I circled that.
Yeah, we may do a memorandum of law. If we find a really good case, then we could do a memorandum of law on it, and then that would be something that would go after all the cases. But if we're going to do a memorandum of law, we got to do it quick because we have to give the other side enough time to review it and respond.
Okay, and then now on tab 4, this is going to be for notes. So I didn't really know what notes are going to be for.
Just a couple. What I like is notes for direct and cross-examination. Yeah, blank paper. What I usually do is I'll put direct when I own witness. I don't need to do it, but for cross, when they're cross, I put my follow-up notes.
Now, would that be for all 3 books? Or just yours?
No, just mine because that's just notes.
So they probably wouldn't have a tab 4, nor they wouldn't have a tab 4. Just be blank. Yeah,
there would be no. Yeah, that's all my internal stuff. Same with the closing statement or closing argument.
And this would be assembly too.
Right.
Okay. Now and again on the closing argument, that's going to be a recap. So that's going to be by you.
Right. All I need for that because I draft that during the trial. So during the trial, I'd just be making notes, and then I'd be
all right.
forming the closing argument.
So basically, tab 3 and tab 2 and 3 are going to be the only really things that I have to do, and those 3 will be basically the same for all 3 books.
Right, and another little trick on this is we don't start actually, because that's like hundreds of pages of photocopying. Sometimes trials we don't do that until literally like the day before. We don't actually.
I'm glad you told me that. That was my second question because I was going to start doing that today, and
sure.
That's what I said. It's voluminous. It's going to be a ream of paper.
No, but it's important, and I think we're pretty much done recording. Thanks, Ben.